You sign contracts with your finger on your phone every day, but are digital signatures actually binding? Hi, I'm Michael Dorff, and I'm the Executive Director of the Lowell Milken Institute for Business Law and Policy here at UCLA School of Law. In the next few minutes, I'll explain why digital signatures are just as good as ink. Believe it or not, the history of digital signatures goes back much further than the internet. Way back in 1869, the Supreme Court of New Hampshire recognized that a telegraph signature could be legally binding. That's how far back these things go. But still, in the late 1990s, as the internet was beginning to grow and blossom and mushroom, it became much more important for states to have uniform rules about electronic signatures. So in 2000, the federal government passed the Electronic Signatures Act, which in essence says that electronic signatures are just as good as handwritten ones with physical ink. It doesn't matter if it's a typed name, a finger swipe, or an electronic pad. The signature is valid as long as there is intent to sign and some authentication of who did the signing. So we have 4 requirements for an electronic signature to be valid. First, we need some kind of identity verification. That could come from a login, it could come from an email address, it could come from a phone number, but we need some indication, some reassurance that the person who signed this document was really you. Second, we need something that indicates an intent to sign, something that shows that this person really wanted to indicate consent to this document. That could be a crazy squiggle with your finger, it could be a thumbprint, it could be a double click on the button, but it's got to be something that indicates that the person who is signing the document really means to do that. Third, there has to be some record of the signature process. Usually that's, again, going to be some kind of electronic record, maybe a PDF of the signature. And finally, there has to be some kind of tamper-evident technology that will indicate if somebody is faking the signature in some way. As with most legal rules, there are, of course, some exceptions. Here we have 5, but what they all have in common is that these are either transactions or documents that are particularly important, and so we want an actual physical signature. First, state documents. Those need a physical signature. Second, divorce papers. That's an important transaction. That needs a physical signature. Third, court orders and notices. Those have to be physically signed by the judge. Fourth, certain documents related to a default, a repossession, or a foreclosure or eviction from somebody's primary residence. Obviously, very important documents. Those have to be signed physically. And finally, the cancellation of either health insurance or life insurance, that has to be signed physically. To sum up, electronic signatures are as valid as physical signatures for most situations. How many digital contracts do you think you've signed this year? Hundreds? Comment below and follow for contract law that actually makes sense.